standard. The home is committed to the prevention of workplace violence, harassment, and discrimination from all sources and will take whatever steps are reasonable to protect employees and other persons in the workplace from such conduct. The home is committed to an environment where all individuals, including employees, residents, and other persons in the workplace, are treated with respect and dignity. As part of this commitment, the home will also ensure that it upholds the prohibitions against discrimination and harassment set out in the Ontario Human Rights Code and the Occupational Health and Safety Act. A Workplace Violence, Harassment, and Discrimination Prevention (WVHDP) and Response Program has been established to implement this policy. Among other items, the WVHDP and Response Program includes workplace violence, harassment, and discrimination awareness training and education. Measures and procedures to control the risks identified in risk assessments. Measures and procedures for summoning immediate assistance when workplace violence, harassment, and discrimination occurs or is likely to occur. Measures and procedures to report incidents of workplace violence, and procedures on how incidents or complaints of workplace violence are to be investigated. This policy applies to all management and workers and addresses workplace harassment from all sources such as customers, clients, employers, supervisors, workers, and members of the public. Employees are expected to share the same commitment to prevent discrimination and harassment in the workplace. Any acts of discrimination or harassment on the part of an employee will not be tolerated and will result in disciplinary action, up to and including termination, as well as other potential action. Employees will not get penalized for reporting an incident or participating in a workplace harassment investigation. Responsive Health Management Copyright 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Leaving threatening notes or sending threatening emails in the workplace. Definitions. As set out in the Occupational Health and Safety Act. Workplace violence is the exercise of physical force by a person against a worker, in a workplace, that causes or could cause physical injury to the worker. An attempt to exercise physical force against a worker in a workplace, that could cause physical injury to a worker, or a statement or behavior that a worker could reasonably interpret as a threat to exercise physical force against the worker, in a workplace, that could cause physical injury to the worker. Examples of workplace violence include, but is not limited to, hitting, kicking, punching, pushing, slapping, pinching, grabbing, biting, etc. Verbal threats of violence. Wielding a weapon at a worker. Throwing an object at a worker. Sexual violence against a worker. Destruction of the property of a worker. Bullying. Domestic violence. Discrimination is any type of behavior that excludes individuals or treats them unfairly because they are members of certain enumerated groups, as set out in the Ontario Human Rights Code. In this regard, the Ontario Human Rights Code provides that individuals cannot be discriminated against in employment because of the following prohibited grounds: race, ancestry, place of origin, color, ethnic origin, citizenship, creed, religion, sex, including pregnancy, sexual orientation, gender identity, gender expression, age, family status, or disability. Examples of discrimination in employment include excluding or treating a member of one of the above referenced groups unfairly, with respect to Responsive Health Management Copyright 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Recruitment and hiring. Promotions. Pay and benefits. Transfers and workforce reductions. Work duties. Harassment under the Occupational Health and Safety Act means a. Engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome, or b. Workplace sexual harassment. Workplace sexual harassment means a. Engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome, or b. Making a sexual solicitation or advance where the person making the solicitation or advance is in a position to confer, grant or deny a benefit or advancement to the worker and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. In addition, under the Ontario Human Rights Code, individuals cannot be harassed in the workplace because of the following prohibited grounds: race, ancestry, place of origin, color, ethnic origin, citizenship, creed, religion, sex, including pregnancy, sexual orientation, gender identity, gender expression, age, family status, or disability. Reasonable actions taken by an employer or supervisor relating to the management and direction of workers or the workplace is not workplace harassment. Examples of harassment include, but is not limited to, threats, intimidation and mental or verbal abuse, unwelcomed remarks, jokes, slurs or taunts. Responsive Health Management Copyright 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Ridiculing the appearance or clothing of another person. Inappropriate and unwelcomed physical contact, including touching, patting or staring. Displaying offensive materials, including sexually explicit or degrading photographs. Isolating or making fun of a worker because of gender identity. Unwelcome comments about a person's body. Unwelcome sexual advances or solicitations. Rude or offensive comments that demean, ridicule or humiliate a person. Any other action that may reasonably be perceived as unwelcome, offensive, or intimidating. Responsibilities. The employer must 1. Commit to zero tolerance of workplace violence, including domestic violence, harassment, and discrimination. 2. Be proactive and prevention-orientated by having workplace processes, procedures and practices in support of a zero-tolerance workplace environment. 3. Provide appropriate information and instruction to employees on the contents of this policy and workplace violence program. 4. Perform a workplace violence risk assessment and reassess at least annually. 5. Take measures and procedures to control the risks of workplace violence, as identified in risk assessments, and inform employees of any outstanding risks. 6. Ensure that employees receive education and training to recognize the potential of workplace violence and that they have the information that they need to protect themselves from risk of physical and psychological harm. Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. 3. Follow this policy and the WVHDP and Response Program. Respond to incidents of workplace violence appropriately. Report incidents of workplace violence. 7. Provide a list of emergency telephone numbers for all employees. 8. Track and report risks of violence, incidents of violence, and close calls to the Joint Health and Safety Committee or Health and Safety Representative, through the use of the Violent Incident Report Form. 9. Ensure that proper medical care is provided for anyone involved in an incident of workplace violence and for securing the safety of employees before investigating the incident or taking reports. 10. Make all necessary reports, as required by law. 11. Advise and/or assist victims to seek police assistance/or file charges. 12. Investigate all incidents of workplace violence, in a fair and timely manner, while respecting privacy as much as possible. 13. Provide confidential assistance to victims of workplace violence. Supervisor/department head must 1. Provide appropriate information and instruction to employees on the contents of this policy and workplace violence program. 2. Take measures and procedures to control the risks of workplace violence, as identified in risk assessments, and inform employees of any outstanding risks. Ensure that employees receive education and training to recognize the potential of workplace violence, that they have the information that they need to protect themselves from risk of physical and psychological harm. Follow this policy and the workplace violence program. Respond to incidents of workplace violence appropriately. Report incidents of workplace violence. Workplace violence, harassment, and discrimination prevention and response program. 2. Participate in any education and training relating to workplace violence. 4. Encourage employees, where possible, to tell alleged offenders about unwelcome conduct or actions perceived to be violent, harassing, or discriminatory. 5. Ensure that proper medical care is provided for anyone involved in an incident of workplace violence and for securing the safety of employees before investigating the incident or taking reports. 6. Complete all necessary reports, as required by law. 7. Advise and/or assist victims to seek police assistance/or file charges. 8. Investigate all incidents of workplace violence, in a fair and timely manner, while respecting privacy as much as possible. 9. Not commit any acts of workplace violence. Employees must 1. Be aware of this policy and WVHDP and response program. 3. Not commit any acts of workplace violence. 4. Inform their supervisors/managers of any incidents of workplace violence. Employees should raise a complaint under this program within 6 months of the alleged violation. Situations older than 6 months that come to management's attention may be addressed if there were strong reasons for an employee not to report the complaint sooner and if appropriate resolutions are feasible, given the passage of time. 5. Know how the employer will deal with incidents, threats, or complaints of workplace violence. 6. Cooperate with the police, company investigators, or other authorities, as required, during any investigation related to workplace violence. Procedure. 1. Risk assessment. The department head shall initiate a process to involve frontline staff and a joint health and safety committee representative in assessing the risk of workplace violence in the work environment, on at least an annual basis. Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. A written report, outlining the results of the risk assessment, will be provided to all parties who took part in the assessment, as well as to the Joint Health and Safety Committee and the Administrator. Once the results have been analyzed by the Joint Health and Safety Committee and the Administrator, follow-up action must be taken to remove or minimize as many risks as possible and to advise employees regarding any outstanding risks. The Workplace Violence Risk Assessment Form should be used for this purpose. A copy of the completed Workplace Violence Risk Assessment will be posted on the Health and Safety Board. 2. Instruction to employees and review. The Staff Development Coordinator/Designate, who is responsible for the orientation of newly hired employees, shall ensure that a copy of this policy and other related policies and procedures are provided to, and reviewed with, each new employee during the orientation process. The commitment statement of the employer and this policy shall be posted so that they are available to all employees. All aspects of this policy and the workplace violence program will be reviewed on at least an annual basis. 3. Education and training. All employees are required to be educated and trained on the contents of this policy. These education and training sessions will be scheduled by the Staff Development Coordinator, in conjunction with all department heads. Education and training shall include: A. The means to recognize potential situations of workplace violence and how to protect oneself from physical and psychological harm. B. knowing the different types of workplace violence, harassment, discrimination, and being familiar with the definition of domestic violence, Workplace Violence, Harassment, and Discrimination Prevention and Response Program. C. Procedures, work practices, administrative arrangements, and engineering controls that have been developed to minimize or eliminate the risk of workplace violence to employees. D. The appropriate response of employees to incidents of workplace violence, including how to obtain assistance, and E. Procedures for reporting incidents of workplace violence. Managers and supervisors should also receive the necessary training to safely supervise all workers. 4. Reporting and investigation. Each and every incident, or close calls, of workplace violence shall immediately be reported to the supervisor/department head, who shall immediately make the appropriate inquiries of the victim to ensure safety and to ascertain whether medical assistance is required. If the supervisor/department head is the alleged perpetrator, or if a conflict of interest is established or perceived, for advice and assistance in resolving this matter, the worker shall immediately report the incident, or close call, to the executive director. In the case that the executive director is the alleged perpetrator, the complaint or concern will go to the VP of Operations for Responsive Health Management Inc. If the employer is the alleged perpetrator, the employer must designate a person who is not under the direct control of the alleged perpetrator. Furthermore, the employee can report to either a board member if applicable, or any other person on the Joint Health and Safety Committee and a third-party organization qualified to conduct a workplace violence investigation who has knowledge of the relevant workplace violence laws will be retained to conduct the investigation. Any employee who believes that he has experienced or witnessed workplace violence should take direct action, if possible, to make it clear to the person causing the offense that such behavior is inappropriate, unacceptable, and unwelcome and should not be repeated. A prior meeting with the department head or supervisor can help in preparing that person to address the other party, whether in person or in writing. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Where necessary, including where an assault occurs, police or emergency responders should be contacted for immediate assistance. The supervisor/department head shall immediately conduct a preliminary investigation of the incident. The executive director and the Joint Health and Safety Committee representative, as appropriate, are to be contacted as soon as possible, to commence a formal investigation. Under the Occupational Health and Safety Act, the employer has a number of duties if a workplace violence incident results in a person being killed or critically injured. Namely, the employer must immediately notify, by direct means such as telephone, a Ministry of Labor inspector, the workplace's Joint Health and Safety Committee or Health and Safety representative and union, if any, and within 48 hours notify, in writing, a director of the Ministry of Labor, giving the circumstances of the occurrence and any information that may be prescribed. If there is an incident of workplace violence and a worker is disabled or requires medical attention, the employer must notify the Joint Health and Safety Committee or Health and Safety representative and the union, if any, within 4 days of the incident. This notice must be in writing and must contain any prescribed information. If required by an inspector, this notice must also be given to a director of the Ministry of Labor. What to do if you have a complaint? The executive director or designate will listen to your account of events and will answer all your questions, on a confidential basis. You will be informed as to how the internal or if required the external complaint procedure works, who will investigate, the length of the process, your right to representation, who will make decisions and the range of possible outcomes. You will be asked to provide a signed, written complaint. The written report must include the following: name, of the complainant and contact information. Name of the alleged perpetrator, position and contact information, if known. Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Names of the witness, E.S., if any or other person, S., with relevant information to provide about the incident, if any, and contact information, if known. Details of what happened including date, S., time, S., frequency and location, S., of the alleged incident, S., and any actions that were taken. Any supporting documents the employee who complains of violence may have in his/her possession that are relevant to the complaint. To list any documents a witness, another person, or the alleged perpetrator may have in their possession that are relevant to the complaint. The resolution the complainant is seeking. The employee will also be provided with any assistance he/she requires to prepare the written complaint. The executive director or designate will proceed on the basis of a verbal complaint pending the submission of a formal written complaint. If the employee is unionized, the union representative will be informed. What to do if you are accused of discrimination or harassment. If you are accused of discrimination or harassment, please cease and desist the conduct at issue. If it was not your intention to act in a discriminatory or harassing manner, please advise the complainant as such and make an apology. Keep a written record of the incident. S. If a formal complaint is commenced, you will be given a full opportunity to respond and to have someone represent you at all stages of the process. Initial assessment of complaint. The executive director or designate will determine whether the complaint falls within the scope of this policy. It may be appropriate to separate the parties within the workplace while the investigation is ongoing. Early resolution procedure. Where reasonably possible, a preliminary investigation shall commence within 24 hours of the executive director or designate being advised of the complaint. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. The executive director or designated investigator will meet with the complainant and thereafter with the respondent and any witnesses, if required. The executive director or designated investigator will inform the respondent as to how the complaint procedure works, who will investigate, the length of the process, the right to representation, who will make decisions and the range of possible outcomes. Where reasonably possible, the executive director or designated investigator will make every effort to resolve the matter through any means deemed appropriate in the circumstances. This can include facilitated meetings, settlement conferences, mediation, negotiation, and conciliation. This process must be initiated within 5 working days from when the written complaint was received by the manager/delegate. If a resolution cannot be reached, the process enters the formal investigation stage. Formal investigation stage. The executive director or designated investigator is to do the following, as part of the formal investigation stage. A. Assemble an investigation team. The investigation may be conducted by an internal or external investigation team, depending on the circumstances. For example, an external investigation team may be required if the respondent is a senior staff member. If an internal investigation team is assembled, it is to include the executive director. An external investigator must meet the legal requirements as specified by the Ontario Ministry of Labour and/or Ontario Private Security and Investigative Services Act and/or by an individual who has been deemed an exempted professional investigator. At the request of the Home's employee, their union steward, their union representative and/or legal counsel and/or a support person, may be present at any stage of the investigation process. The investigation shall start no later than 2 weeks from the time that the complaint is received by the person, S, responsible. B. Gather all relevant documents. The following documentation should be obtained as quickly as possible. I. The signed, written complaint. 2. A written response from the respondent, if they wish to provide one. 3. Any relevant policies and procedures. 4. Documentation relating to prior incidents involving the respondent, and Workplace Violence, Harassment, and Discrimination Prevention and Response Program. IV. Any other relevant documents, including hard copy and electronic files. C. Conduct interviews. The objective of the interview is to elicit and record as much detail about the incident as possible, including the date, time, location, persons who saw or heard the incident, what happened before, during and after the incident, whether the incident was previously reported and any previous action taken, etc. Whenever possible, open-ended questions should be used to allow the interviewee to tell the story in his/her own words. The person making the report is the first person to be interviewed. Thereafter, the respondent and any other witnesses are to be interviewed. Any person being interviewed is entitled to have a representative accompany them at the interview. The alleged perpetrator, S, must be given the opportunity to respond to the specific allegations raised by the worker. In some circumstances, the worker who allegedly experienced the workplace violence should be given a reasonable opportunity to reply. All persons are to be interviewed separately. The executive director or designated investigator may decide to conduct second interviews of any person, if determined to be necessary, at his/her sole discretion. D. Document interviews. Careful, accurate, and succinct notes are to be taken at each interview, which should record the following: I. The date of the interview. 2. Who was interviewed. 3. Who was present during the interview. 4. The author of the notes. V. Where the interview took place. 6. The questions asked. 7. The answers provided, and 8. Whether the information provided arises from direct knowledge or hearsay. To reach a decision, the investigation team is to analyze the evidence obtained, make conclusions based on the evidence and prepare a report. The report should summarize the complaint. Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. 2. Identify any interim steps taken pending the completion of the investigation. 3. Summarize the evidence obtained. 4. Identify any inconsistencies. V. Assess credibility and weigh competing evidence to attempt to reach factual conclusions, and 6. Explain the reason for any conclusions reached. The report is to be provided to the executive director or vice president of operations, who is to make a final decision, including with respect to any follow-up or disciplinary action to be taken. Corrective actions may include human rights training, sensitivity training, mandatory counseling/therapy, progressive discipline, an apology, a behavioral contract, etc. The corrective action is to be consistent with the principles of fair discipline. Where it appears to the investigator and person, S, responsible that A. The subject matter of the complaints trivial, vexatious, or made in bad faith, or B. The facts upon which the complaint is based occurred more than 6 months before the complaint was filed, unless the person, S, responsible is satisfied that the delay was incurred in good faith and no substantial prejudice will result to any person affected by the delay. The investigator may decide to not deal with the complaint. No complaint will be regarded as substantiated or unsubstantiated until it has been investigated. The investigation must be completed in a timely manner and generally within 30 days or less unless there are extenuating circumstances, i.e. illness, complex investigation, warranting a longer investigation. F. Communicate the outcome. The decision, including any follow-up or disciplinary action, is to be communicated to the following persons: I. The complainant. 2. The respondent, and 3. Any party required to be advised by law. If a finding of violence or threat of violence is made against a respondent who is a staff member, the decision, and any follow-up or disciplinary action, is to be communicated to the respondent, in Workplace Violence, Harassment, and Discrimination Prevention and Response Program. The presence of a union steward, by the executive director or the vice president of operations. Furthermore, within 10 days of the investigation being completed, the worker who allegedly experienced the workplace violence and the alleged perpetrator, S, if he or she is a worker of the employer, will be informed in writing of the results of the investigation and any corrective action taken or that will be taken by the employer to address workplace violence. Record keeping. The employer will keep records of the investigation including a copy of the complaint or details about the incident. b. A record of the investigation including notes. c. A copy of the investigation report, if any. d. A summary of the results of the investigation that was provided to the worker who allegedly experienced the workplace violence and the alleged perpetrator, if a worker of the employer. e. A copy of any corrective action taken to address the complaint or incident of workplace violence. Confidentiality. The employer understands that it is difficult to come forward with a complaint of workplace violence, including domestic violence, harassment, and discrimination, and that it is in the interest of the parties to keep the matter confidential. Rumors and innuendos are destructive. To protect the interests of the complainant and the respondent, confidentiality will be maintained throughout the process to the extent permitted by law. Advisors/investigators will not disclose any information unless the disclosing party gives permission to do so except as required. A. By WVHDP and response program procedures. b. By subpoena or legislation, i.e. OHS Act, Criminal Code, Labor Board, etc. Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. c. By a danger to life, health and safety. Complainants and respondents must have access to statements they have made and personal information which they have provided. Respondents and complainants must have enough information about the allegation and responses of other parties and witnesses to enable them to make a defense or a rebuttal. Personal information must only be used when administering this WVHDP and response program, processing complaints, determining the appropriate means to either address, manage, or resolve violations, including appropriate disciplinary and other remedial actions, or for a consistent or related purpose. There must be no reference to a complaint under this policy in an employee's personnel file unless disciplinary action was taken against the employee. Prior to finalizing an investigative report, copies of a draft investigative report must be shared with the parties, complainant and respondent, so they can comment on the accuracy and completeness of facts. Parties may not share the draft report with anyone other than the person who accompanied them to complaint-related meetings and/or their bargaining agent representative and/or their legal representative. A final copy of the investigator's report, including its findings, will be provided to the parties, complainant and the respondent, in accordance with the Occupational Health and Safety Act. Reprisal and bad faith. You have the assurances of the home that all complaints will be immediately and thoroughly investigated and that any employee that brings forth a complaint in good faith will not suffer any form of reprisal or adverse treatment. Allegations of workplace violence are serious. Any employee who makes such an allegation in bad faith may be subject to the disciplinary action, up to and including termination, as well as potential legal action. Legal action. Nothing in this policy prevents or discourages an employee from filing an application with the Human Rights Tribunal of Ontario on a matter related to the Responsive Health Management 2010. All rights reserved. Revised, October 11, 2019. Workplace Violence, Harassment, and Discrimination Prevention and Response Program. Ontario Human Rights Code. An employee also retains the right to exercise any other legal avenues that may be available. Outcome. 1. A healthy and supportive work environment, free of any type of workplace violence, harassment, discrimination, and human rights violation. 2. There is an internal and external, if required, mechanism for addressing complaints involving workplace violence, harassment, and discrimination. 3. All employees will feel comfortable and know how to report any incident of workplace violence, discrimination, and harassment. Additional references. Occupational Health and Safety Act, updated September 2016. 1. 2 ASIS International, Workplace Violence Prevention and Response Guidelines, 2006. 3 BC Government and Services Employee Union, 2007, Caring Shouldn't Hurt, Violence Prevention Handbook. 4 International Council of Nurses, 2007, Workplace Bullying in the Health Sector, Fact Sheet Geneva, Switzerland. 5 2181. 6 Ontario Safety Association for Community and Healthcare, now known as SHSA, Bullying in the Workplace, 2009. 7 Registered Nurses Association of Ontario, 2008, Position Statement, Violence Against Nurses, Zero Tolerance for Violence Against Nurses and Nursing Students. 8 Scott and Associates Incorporated, 2019, Workplace Violence, Harassment and Discrimination Program. Ministry of Labor, 2009, Bill 168 and the Occupational Health and Safety Act viewed November 3, 2009. And Bill ID equals Workplace Violence, Harassment and Discrimination Prevention and Response Program. 9 Ontario Human Rights Code. 10 Bill 132, Sexual Violence and Harassment Action Plan Act, 2015. 11 Health and Ontario Ministry of Labour, Workplace Harassment under Ontario's Occupational Safety Act, August.